Hi, I'm attorney Robert Spear. The purpose of this video blog today is to give you a brief introduction to the bankruptcy process overall, kind of how it works, and to discuss a little bit about how a Chapter 7 and a Chapter 13 bankruptcy works, like I said, in a very brief and kind of an overall sketch format. And we'll talk more about detailed portions of the bankruptcy code and how it can help you change your life for the better on later video blogs. So, just to kind of get right down to it, when you're looking at filing a bankruptcy, the first thing you always have to do is file a bankruptcy petition. Now, the purpose of the petition is to open up your case, and it's also to give notice to your creditors and to any other interested persons that you filed a bankruptcy, and it's also to allow the court to have certain information so that the bankruptcy trustee and the court, if necessary, can protect everyone's rights, your creditors' rights and your rights in the bankruptcy case. So it has those three purposes. We help you prepare the bankruptcy petition by getting information from you, first of all, because you are the one who has the information we need, but also by pulling credit reports and doing other searches for information so that we can put together your petition for you as quickly as easily as possible with minimal amount of work on your part, and also to make sure that it's accurate. Once we prepare that petition, we have you come in and sit down with us. We go over that petition with you, make sure that everything in there is correct, and then have you sign off on that petition. One of the things the petition also does is allows us to predict what's going to happen in your bankruptcy case. There's a lot of things that can happen in a bankruptcy case that if you're not prepared for it can be kind of a nasty surprise. But if you're prepared for the potential problem, you can avoid it or be prepared to deal with it. So surprises are bad, and we want to make sure before we ever file your case that we've looked at everything in your petition so that we know what's going to happen. That's also another reason why it's very important that you be very open and straightforward with us. Anything you say to me, of course, in discussing your case is confidential. I can't go talking to other people about that, nor would I ever do that. And so I want you to be comfortable and feel like you can tell me anything and be open and candid. But that also has the benefit of helping you so that we can predict what's going to happen in your case. Once we've filed your petition with the bankruptcy court, about 30 to 35 days later, you will have a meeting of creditors. The bankruptcy trustee that's appointed for your case runs the meeting of creditors, and it's that person's job to look at your petition and make sure everything in the petition is accurate, to make sure that all the information that the trustee needs is there, and also then to take a look at your property and divide it up into two parts: the property that you get to keep and the property the trustee gets to take. One of the reasons we want to have a complete picture of your financial life before we file the bankruptcy petition is to be able to predict and protect property for you so that you lose as little as possible, and probably in most cases in a Chapter 7 here in Nevada, nothing to the bankruptcy trustee. What's most commonly taken by the bankruptcy trustee is a portion of a tax return that might be, or a tax refund that might be available to you. Sometimes cash, but generally in Nevada, if you do a little bit of planning, you'll be protected for the most part. The bankruptcy trustee's job is also to make sure that your creditors have received proper notice. That's again why we have to provide your creditors notice of your bankruptcy case. So we provide the court in your petition that your creditors' contact information, like an address. And at the meeting of creditors, the trustee can also allow those creditors to ask you questions. Of course, I'll be sitting with you in your meeting of creditors. You're never going to sit in front of that trustee or with your creditors without me being present. I'm there to protect you and to make sure that things run smoothly and well for you. But creditors do have the right to ask you questions in a meeting of creditors. That's rare. Probably 1% to 2% of the time over the period of my career do creditors ever show up at a meeting of creditors. They usually write off your account and your case as soon as they see the bankruptcy court filing, and they never show up. There are some circumstances where creditors will more often than not show up, meaning, if they're going to show up, it's usually going to be one of these circumstances, either in a case where there's a divorce associated with your bankruptcy, so an ex-spouse or a soon-to-be ex-spouse will sometimes show up at a meeting of creditors to ask questions, or a lawyer for your ex or soon-to-be ex-spouse. If you have a business that's failed and that's part of the bankruptcy, sometimes business creditors will show up in order to ask some questions. And then if there's a fraud associated with your case, Sometimes creditors will show up to ask questions. For the most part, though, those are very rare. I've seen spouses or soon-to-be ex-spouses show up and ask questions at a meeting of creditors from a client of mine. But the trustee will usually keep that to a minimum and keep it as friendly or as professional as possible, and I'm also there to make sure that happens. If there's a business associated with a case, I've seen creditors show up for that. And again, that's usually just the creditor asking a question about where's my collateral, or is there anything left in the business accounts, and they just want to make sure that anything they're entitled to from that business is still protected. I don't think I've ever had a client that, as I sit here and think about it today, that's been guilty of some sort of a fraud, although I've appeared for banks at meetings of creditors before and asked questions of people who'd committed fraud or embezzlement. But that's again rare, and if you have a circumstance like a divorce or a failed business, we'll know about that ahead of time, and we'll be able to prepare for any questions that might come from creditors. But usually it's a pretty painless process at a meeting of creditors, fairly quick. There are other people in the room with you, but they're all bankruptcy debtors too, and they're going through the same process you are, so they're not really paying attention to anything that's being asked about you. They're thinking more about their own case. So it's not the most private meeting in the world, but again, pretty painless, and for the most part, everyone's going through the same thing. Once you've finished your meeting of creditors, if you're in a Chapter 7 bankruptcy case, your discharge will come through and get entered by the court 60 to 90 days later. You'll get the copy of that in the mail, and what that means is that you no longer owe the debts that you listed on your bankruptcy petition. There are some exceptions to that rule. Certain things like student loans are not dischargeable, and some other types of debts, but I'll discuss that later on a different blog. A discharge also frees you from any contracts you might have been a party to that you're trying to get out of that will be bad for you or bad for your finances if you stay in them. Sometimes people have business leases that they need to get away from, or a car lease, or other contracts, and so those are also wiped out, and you no longer are liable on those contracts. If there's a contract you want to stay a party to, like a car lease, you can certainly choose to do that as well. But you get to go through and choose that as part of your bankruptcy process, so that you can reorganize your life, and that's how we help you change for the better, or one of the ways. If you are in a Chapter 7 case, that's pretty much it. Once you've got your discharge, that should be the end of the line for you. The case may remain open for the trustee to do some business, administrative business in the case, but you should be done with the case and shouldn't have to worry about it from that point forward. If you're in a Chapter 13 case, once your meeting of creditors is over with, the court will go ahead and take a look at your bankruptcy plan and the payments you're making under the plan and the different parts and terms of the plan to make sure that that's all legitimate. The trustee is the one that really goes through that, but the court has to approve your plan. And once your plan's approved, then you just keep making payments for either 36 months or 60 months, depending on how long your plan is. And that's the end of it. That's how a bankruptcy case works. Once your Chapter 13 plan payments are finished, you get a discharge of any unpaid debts there, and you walk away from it, and that's the end of your bankruptcy case. So that's an overview of the process. There are specifics that I'll go over, like I said earlier, in more detail in other video blogs. For instance, what property do you get to keep, and what property can your trustee take? What liens or rights to collateral do your creditors have, and what can bankruptcy do for you in that area? Some of you may know that, or may have heard that you can strip a second mortgage off a home in some circumstances. You can also make changes to car loans and do other things like that through the bankruptcy process to help you change your life for the better. So that's another blog we'll talk about in the future. I'll also talk about what debts are dischargeable and not dischargeable. So what debts are gonna keep with you going forward, and maybe some ways to deal with that, and other topics as well. So there's a wide variety of things that the bankruptcy process can do to help you change your life for the better and move forward and get a fresh start. But again, that's the bankruptcy process in a nutshell. If you have any questions, obviously, please feel free to call us at any time. we're happy to have you come in and sit down with us and discuss the specifics of your case and help you move forward and change your life for the better.